In a decision issued Wednesday in Los Angeles, District Court Judge Otis Wright concluded that the court lacks personal jurisdiction over Lujan. Lujan's motion to dismiss based on a lack of personal jurisdiction is granted. Lujan's attorney, William Hebert, told PNC News by phone from San Francisco today that it was the outcome they had argued for all along.
I just want to say how happy we are that the case was dismissed against Mr. Lujan in California. We thought from the very beginning that it wasn't fair to expect Mr. Lujan to defend a case in California. We thought that, and the judge agreed with us, that it wasn't reasonable, that he doesn't have contacts with California, and that the facts underlying the dispute arose really in Guam and in the CNMI.
Judge Wright's order notes that the complaint filed by Hillbroom alleges a broad conspiracy among the defendants to defraud plaintiff out of millions of dollars he received in connection with the settlement of his deceased father's multi-million-dollar estate. However, Judge Wright did not rule on the merits of that complaint against Lujan. The judge writes that the court finds that it is without general jurisdiction over Lujan. Indeed, Lujan only briefly attended school in California and maintains a mere passive website. What tips the scale, he wrote, is California really has no interest whatsoever in seeing this action through. Hebert, however, said that the case moves forward on the other two defendants, Keith Weibel and Barry Israel.
There are still two defendants, Barry Israel and Keith Weibel, who was the trustee of the JLH Trust. As far as next steps, that really is the next thing that's going to happen, is that the judge is going to make some decisions about how to go forward against those remaining two named defendants.
The dismissal victory for Lujan comes following reports that the law firm that successfully represented him is pulling out because it has not been paid. In a letter written by Lujan to Calvo and Clark, dated February 22nd of this year, Lujan writes that he has been billed more than $676,000 for the Junior versus Lujan case, and in two other Hawaii cases, Weibel versus Lujan, billing $69,000 plus, and in a Guam case, $377,000 in legal fees. There is simply no justification for the amounts billed, writes Lujan. How can the California case be billed at $676,000 when the pleadings have yet to be joined? How can the two Hawaii cases be billed more than $92,000 when your firm is not even in the case? How can the Guam case be billed $377,000 when all that has occurred is a removal and a remand back to Superior Court? I have reviewed your letters, writes Lujan, and I beg to differ with your explanations. I simply cannot accept these invoices. We must resolve our differences in a realistic and reasonable basis. A drastic reduction is in order. Ironically, Lujan is protesting legal fees charged by a law firm that is, in part, representing him against claims that Lujan himself overcharged a client of his own. Kevin Kerrigan, PNC News.